Continuing motion hearing, July 2006, John Byrne, cross-examination by Attorney Fallon. You have the exhibits in front of you? Just 13. All right. The court. Counsel, your microphone is still on there. Attorney Fallon, may I approach the witness? The court. Yes. By Attorney Fallon. Lieutenant, I'm showing you what has been received into evidence as evident as Exhibit number 8. Are you familiar with that form? Yes. And do you know its purpose? There's two answers here, forms here, the Fifth Amendment or the notification. And my attention is I'm directing your attention to the top part of the Fifth Amendment form. Yes, the purpose is to ensure that the jail staff understands and makes any law enforcement officer that may come into question an inmate and understand that that inmate has invoked his Fifth Amendment rights, does not wish to give a statement without an attorney present. So, that's to alert any other law enforcement officer who may wish to interview a defendant or suspect or on any other crime or any other matter that they would be prohibited from doing so because the individual has invoked his right to counsel on unrelated and related matters. Correct? Correct. All right. And that's for law enforcement personnel seeking to come in and interview a given inmate who is detained at the jail. Correct. Okay, now you've indicated in your direct examination that there were at least two distinct classes or groups of individuals and that the rules were different for purposes of facilitating visitation. Is that correct? Yes. And one group or one class of individuals, you have lawyers, clergy, probation and parole, and medical personnel. Yes. And on the other side of the ledger, the other group, we have family members, friends, relatives, and perhaps other members of the general public. Correct. All right. Now, I believe also you said in your examination there wasn't anything specific in the visitation rules governing contacts with the media. Is that correct? That's correct. All right. So for purposes of assessing the media, is your opinion which category does the media fall into? Do they fall into the lawyers, clergy, professional, law enforcement, doctor group, or would they fall into the family, friends, relatives, and other group? Who would consider them professional visitors as a doctor or an attorney? All right, why were they afforded that professional status? Well, because generally they are not family and the inmates are limited to a specific number of friends that can visit. I guess to allow the visitation, which the inmate does have a right to access the media, we just consider them a professional visit. Well, let's talk about the right of access to the media. Where does that come from? The courts uphold that inmates have certain rights in jail, such as access to the courts, access to their attorneys, access to their legal materials, and access to the media or other organizations that do help them. Now, is that something that you learned in training? Yes. Could you tell us about that, please? I believe specifically I attended a Department of Corrections seminar on writing policies and procedures, and part of the materials that were provided talked about specific inmate rights that should be protected. All right, so would it be fair to say that you were sensitive to a given inmate's right to have access to the media? Correct. So sensitive to their First Amendment right to free speech? Correct. All right, and does that sensitivity somewhat inform you in exercising your policy of reasonableness? Yes. All right. There was a fair amount of discussion relative to flexibility that needed to be afforded to permit professional visits. Is that correct? Yes. All right. As a matter of fact, Monday in Calumet County is a criminal court intake day. Is it not? Yes. And things get rather hectic in that particular day, correct? Yes. There's a lot of court appearances to be held. Yes. And as a result, there's a lot of visits by retained counsel for inmates. Yes. As a matter of fact, there may very well be visits by state public defender's office doing indigency evaluations and things of that sort to see if some of the some in custody person is entitled to a right of counsel. Correct? Correct. Now, on a given day like that, do you sometimes have to call in extra personnel to make these visits happen? Yeah, we generally like to, if we can, staff heavier on busier court dates. I believe you said the staffing is somewhat more limited on weekends. Is that correct? It's limited in a way that there's not always a supervisor working. The corrections officers depend more on patrol supervisors to assist them. All right, and in terms of the correctional individuals, or sometimes referred to as jailers, the staffing, does that depend on the number of inmates that may be housed at any given time in the jail? Do you have to put on extra staffing? In other words, if you're full versus half full, for instance. We prefer, but there's so many factors that influence it, and that's really hard. We like to have as many working as we can, but as I said, there's a lot of factors that limit it. And those factors then necessitate an exercise of reasonableness in attempting to facilitate visits that someone that any given inmate may have wish to have. Yes. All right, let's talk about the situation with Jennifer Colbus. As I understand your testimony, she provided you with a letter briefly explaining that her purpose for visiting Mr. Avery. Is that correct? Correct. And you examined the letter? Yes, I reviewed it. All right, and you found it to be appropriate under the circumstances? Yes. And you took that letter and you went down to Mr. Avery's cell, correct? Yes. You handed him the letter, correct? Yes. You waited for a reply? Yes. And what we didn't hear, what was his reply? Said he would talk to them. All right, at that particular point, was he at all hesitant to grant the interview? Didn't appear to be. He studied the letter, thought about it, and he agreed to it. All right, at any time during your contact with him, did he express an unwillingness to meet with them? No. As a matter of fact, you gave him the letter, correct? Yes. You never took the letter back, correct? No, I did not. For all you know, that letter is still in his possession to this day. Probably, unless he disposed of it. All right, and there was, I will withdraw that. When you were discussing with him the fact that Ms. Colbus from Channel 5 was wanting to interview him, he never once mentioned an attorney, Eric Lloyd, to you, did he? No. As a matter of fact, he never mentioned once to you Exhibit 9, which was the handwritten letter that he wrote out and what was found in your files, correct? No. As a matter of fact, there was no real hesitation whatsoever in terms of his willingness to meet with you with a reporter, correct? Correct. And that held true, as far as you know, for both interviews conducted by Ms. Colbus on the November 18th letter circumstance we were just talking about, and the December 14th. Correct. Now, with respect to the media access issue and Mr. Avery, it's true, is it not, that initial counsel, in his case, Eric Loy, and his associate were concerned about the interview given to the media by their client, Mr. Avery, correct? Yes. As a matter of fact, he was not heeding their advice not to give those interviews, was he? No. And as a matter of fact, the change in policy that you alluded to by Sheriff Poggle came in at the request of the attorneys that basically, in effect, asking for a favor that he not grant access or pass information to their client, correct? Correct. Attorney String, personal knowledge here, but I think we need some foundation. The court, I will sustain the objection on the foundational grounds at this point. By Attorney Fallon. What's your understanding as to why there was a change in policy in January of '06? As I explained earlier, my understanding from the conversations with the sheriff was that Mr. Avery's counsel at the time had requested that we no longer grant access by the media to Mr. Avery, and the sheriff at the time was changed his policy of passing notes asking if Mr. Avery wanted to do an interview and, in effect, stopped it. All right, and that specifically, was that the request of his attorneys of record at the time? That was my understanding. All right, now in terms of the interview, who were granted interviews? Well, let's rephrase that. In terms of the individuals for whom Mr. Avery agreed to be interviewed, those interviews were conducted by Emily Matesic, correct? Yes. All right, and they were also an interview conducted by Jennifer Colbus, correct? Yes. And it is true, is it not, that Mr. Avery declined to be interviewed by Mark Leland from Fox 11 News, correct? Yes, it's in the jail log. As a matter of fact, in the jail logs, the individuals to whom Mr. Avery granted interviews were all women, correct? Correct. As a matter of fact, for instance, Ms. Mastasic and Ms. Colbus are young, attractive, dark-haired professional women, correct? Attorney Strang, stipulated. Answer, correct. By Attorney Fallon. One other matter, in November and December, which is the time frame in question, it was customary for you and or other jail staff to sit down and have discussion with Mr. Avery as to how he was doing, how he was adjusting to the jail, correct? Yes. As a matter of fact, you would review everything from his visitation list to his medication needs to his entertainment needs, whatever the case may be. You wanted to see if he was adjusting correctly. Yes. And comfortably. Yes. All right, and how often would these meetings take place with Mr. Avery? I couldn't say specifically. I know I tried to speak with him weekly. It's probably not that frequent anymore. And as a matter of fact, you did have a meeting with him on November 10th. Would that be correct? I guess. Well, perhaps I can show you a page from the report. Exhibit 14, marked for identification. Attorney Fallon, may I approach? The court, yes. By Attorney Fallon. Lieutenant, I show you what's been marked for identification purposes as Exhibit 14. Is that correct? Yes. Directing your attention to the last entry on Exhibit 14. That's a narrative that Sergeant Hamar wrote about a meeting that we had with Mr. Avery. Tell us about that meeting. What does the entry say? I will read it. Earlier this afternoon, J.E. Byrnes and I invited inmate Avery into the office to discuss any concerns, requests, or complaints he may have. Inmate Avery, he is doing as good as can be. I asked inmate Avery if everything was working properly in his housing unit. The only complaint inmate Avery indicated were that sometimes the water in the shower is too hot and the reception on the television is poor. Inmate Avery stated that he has no problem with correctional staff that's all. Attorney Fallon, I believe the next page is already an exhibit. No, it's not. All right. The court, if you're going to add a page, can the parties agree to just make it part of? Attorney Fallon, yeah, I'm going to add page 4 in the interest of completeness. The court, all right. Attorney Strang, sure. Attorney Fallon, all right. There's the rest of that note. Would you continue, please? It's again on the first page. Inmate Avery stated he has no problems with the correctional staff and is being treated okay. I asked inmate Avery about a report by a television station, and his mother made the comment he is depressed. Inmate Avery stated that he was doing okay. Inmate Avery was advised that he should he ever need services from the Calumet County Department of Human Services, the jail will assist him in arranging to have someone speak with him. Inmate Avery again stated that he was doing okay and would let correctional staff know if he needed assistance from CCDHS. Lastly, we talked about being housed alone. Inmate Avery stated that he's okay with it, but sometimes he wishes he had someone to talk to. Inmate Avery made the comment that he's facing more time this time than the last. It was decided that inmate Avery will continue to be housed alone, but will be revisited as at inmate Avery's request in the future. Inmate Avery thanked J.A. Byrnes and myself for our time and was turned over to the correctional staff. Thank you. So it would be fair to say, or would it be fair to say, that those types of meetings or debriefings would occur periodically during his detention? Yes. And at that particular meeting, it's obvious he didn't have any concerns or express any problems with having the media interviews, correct? Correct. So during the course of these periodic reviews, to your recollection, did he ever, and I'm now talking specifically from the time frame of November, well, that note was November 30th through December 15th. Were there ever any concerns expressed by Mr. Avery regarding, geez, I just don't want any more media contact? No. Attorney Fallon, I move into evidence Exhibit 14 and tender the witness for redirect. The court, any objections? Attorney Strang, no objections. The court, all right, the exhibit is admitted. Mr. Strang. Redirect examination by Attorney Strang. With respect to an inmate's access to the media, discussed on cross-examination, one of the things that an inmate ordinarily has available to him is the jail is a telephone. Correct. Each block or pod, however the jail is organized, has such a phone? Yes. That phone can be turned off by jail staff? Yes. Attorney Fallon, objection beyond the scope of cross. Attorney Strang, it's clearly within. The court, I'm trying to remember. Mr. Strang. Attorney Strang, all I'm going is Avery was able to initiate calls to the media by telephone. Attorney Fallon, I don't recall bringing that up on cross-examination. Attorney Strang, yes, the right of access to the media and his training on the right of access to the media. The court, yeah, I will allow the question. By Attorney Strang, this is a phone that can be turned off by the jail staff. Correct. But unless it's abused, ordinarily it's on. Correct. Doesn't receive incoming calls. No. But the inmate can place outgoing calls to collect. Yes. There was a short time in March of 2006 where you turned off Mr. Avery's phone, or at least moved him to a cell that had no phone, correct? Attorney Fallon, objection. Relevance as to what went on in March. We're talking about November and December. The court, Mr. Strang, what's the Attorney Strang? It's just a counterpoint. Where I'm going is, other than for a very brief period of time in March, he had access to a telephone and could collect calls. The court, I don't know that that's contested. I'm going to sustain the objection. By Attorney Strang, Mr. Avery, to your knowledge, was able to place collect calls to any media outlet he wished who would accept his collect call. Correct. We discussed the 3 interviews, television interviews, Mr. Avery did not request, and the 1 television interview he did request was turned down. And Mr. Fallon explored the sex and physical characteristics of the reporters. The 1 reporter Mr. Avery ever asked to speak was a gentleman named Aaron Keller, wasn't it? I'm not familiar with Alan Keller, pardon me, but the note indicates he. Finally, the November 30th meeting, which I understand was one of the similar meetings that you had with Mr. Avery. Yes, correct? And so you were the jail administrator, and with you for the meeting was your jail sergeant, Sergeant Hamar? Correct. During the period of November and December 2005, were you and Sergeant Hamar in the habit of regularly visiting every inmate of the Calumet County Jail to inquire how they were doing, whether he was depressed whether the water in the shower was too hot, how the TV reception was doing. Were the two of you running around and talking to every inmate during that time period about these solicitous matters? I would say that we didn't have a formal meeting with them. I'm not sure how formal this was, but yeah, we kept in touch with inmates. And I mean, I want to know what's going on and how they were doing. And he is not the only inmate in there, and not the only one I'm concerned about. Sure, but I've had a chance to look at the jail log, and we have only marked a few pages in it, but I don't see that there's that sort of attention to other inmates. Am I missing something, or was Mr. Avery a little bit different? The jail log that you were provided are entries that deals solely with Mr. Avery, nothing with the other 40 or 50 inmates that we house. That log was provided by querying his booking number, and from that I obtained all the log entries specific to him only. Very well. So the question, really, the final question is, was Mr. Avery treated differently in terms of their solitude and the jail sergeant and the administrators visiting him and making these sort of inquiries? Was he treated differently in the last 2 months of 2005 than the other 40 or 50 inmates? No. Attorney String, that's all I have. The court, any other questions? Attorney Fallon, nothing further for the witness. The court, you may be seated. The witness, thank you. The court, does the defense have any other witnesses on this motion? Attorney String, we do not. The court, any other witness for the state? Attorney Fallon, one moment, we have nothing further. The court, all right, I know each party has submitted a written argument in the support of their position on their motion. Does either party wish to be heard orally after today's evidence on the motion? Attorney String, I would like an opportunity to get a transcript, which I'm willing to pay for on an expedited basis, and submit a written argument, because I think that we will find no case that directly controls this on the question of where the line falls on the citizen becoming de facto an agent of the police. I think it's an interesting issue, and I would like a chance to look at the testimony and argue it in writing. Attorney Fallon, Your Honor, I guess I would disagree. I think there is a case law both in Wisconsin and elsewhere. I cited some of it in my brief. We have argued it. We have done our preliminary research. We've taken the testimony, and I would be prepared to orally argue further comments based on the testimony while it's fresh in our minds. The court, I think on the general question, the memoranda submitted by both parties adequately addresses the point. There was I don't know that the written memoranda was addressed to the significance, if any, of the written request that was made by the defendant not to have access to any media people. Attorney String, no, we have none of that at the time of our memoranda. The court, all right, in light of that fact, I will grant the request to allow two parties to submit written argument, a supplemental memoranda on this issue. I will just make it due by August 9th. Discussions about expedited transcript. The court, I also think that parties can probably start researching their memoranda before they get a copy of the transcript. I don't think the evidence is that complicated here. Attorney Fallon, let me ask, Judge, are you contemplating then a simultaneous filing, since each already have filed our initial replies or responses, so that each party will file our final position by the 9th? Is that the contemplation? The court, yes, that is exactly what I contemplate. Attorney Fallon, that's fine. The court, all right, then we move on to the Frank's motion regarding the basis for the search warrant. I believe the defense is going to begin here. Mr. Buting, are you handling this one? Attorney Fallon, excuse me, Your Honor. Before we begin, if I could have a moment, since I'm done with this one as well, to reorganize my paperwork. But I would like the right to be heard on whether or not the pleading is sufficient to justify an evidentiary hearing on the part of the defense motion dealing with the Franks issue. The court, all right. Attorney Buting, Judge, I think the state has had an opportunity to respond to this motion for several weeks. If they were going to reply and object to this motion of being heard, having a hearing on that part of it, they could have filed it in writing. I can't say that I have all the case law at my fingertips right now on these issues because it wasn't raised as a concern until right now. The court, Mr. Fallon, Attorney Fallon. Yes, Judge. Well, I would like to have had time to file a more written rendition of the argument I'm about to make, but like other counsel, I've been away from my office quite a bit in the last few weeks, and I did write a brief for the November 5th pleading, and I wrote a brief with respect to the issue we just had. I did not have time to write a third brief. That's all I can say. I would like to note for the record that in reading the case law, the courts have oftentimes footnoted comments regarding the fact that the issue was not raised at trial court and probably should have been raised, so I did not want to be put into this situation should there be an appellate review of not having argued the point. The court, all right, I will acknowledge that you have raised the issue at this time, and I will take it under advisement. But I think given the fact that I haven't had a chance to review any arguments that may have been made either, I would have difficulty ruling on it at this time, so we will proceed with the evidentiary hearing. Attorney Fallon, at some point may I submit at least a brief of what my argument would have been had the court entertained it, just to preserve the record. The court, yes. And if it turns out that the court can still grant your motion, Attorney Fallon, all right. The court, even if I take evidence today, if the court is satisfied that the defense wasn't entitled to an evidentiary hearing based on the material provided. Likewise, Mr. Buting gets an opportunity to make the counter argument. Attorney Buting, all right, thank you. The court, and I will suppose we should have that due by August 9th as well. Attorney Buting, my witness is probably in the hall. Let me check. Attorney Fallon, Your Honor, I will let you swear the witness, but there's one other housekeeping matter I thought we might want to take up regarding the scope of the claim so that I'm certain I know exactly what the defense is wishing to accomplish in terms of what is to be suppressed and what is not. The court, okay,